I take this time while someone is writing something eventually to introduce the next speaker, Audrey, from our sister and firm Santarelli. We are very happy to have you here with us today. Audrey will talk about evidence, so the reversing the dynamics of evidence production, and in particular about the case Labs versus GC Aesthetics. So let me check if any question has been raised so far. No questions. So please, Audrey, the floor is yours.
Yes. Thank you, Mario. Just to confirm, can you see my presentation?
Yes, we do.
Yes.
Yes? Okay, thank you. So this presentation, as you say, Mario, will focus on the analysis of a recent decision issued by the Brussels Local Division on last 14 April concerning an application for the production of evidence. Just briefly, before turning to the analysis of the decision, just a brief reminder of a general UPC principle regarding the burden of proof. So as you know, the UPC framework is based on a fairly traditional approach. Each party must prove the facts it relies on. So if a party alleges infringement, invalidity, prior use, or any other factual element, it is for that party to bring the supporting evidence. And this principle is expressly set out in Article 54 UPC agreement that you can see on the screen, which states that the burden of proof of facts shall be on the party relying on those facts. And this principle is also reflected in the rules of procedure, notably rules 171 and 172 and the rule 13. And in light of this principle, Article 59 of the UPC agreement and Rule 190 create a mechanism allowing a party to obtain evidence that is not publicly available and is under the control of the opposing party or even a third party. And the purpose is therefore to support factual allegations where the relevant evidence cannot otherwise be accessed by the requesting party. So procedurally, the mechanism requires a reasoned request and may be used during either the written or interim procedure. Disclosure may be ordered after the other party has had an opportunity to be heard by the court. And the framework also strongly protects confidential information. Any disclosure orders remains also subject to appeal. And most applications have been initiated by claimants seeking access to financial, commercial, or technical information relevant to infringement or damages. So you can see the different categories of documents that have been requested by applicants so far. And in practice, this has involved requests for confidential license agreements, particularly in France disputes, and documents already disclosed in US discovery proceedings, for instance. But orders to produce evidence may also be requested by defendants of the main procedure, as illustrated by the Court of Appeal decision in Guangdong Oppo versus Panasonic, which was the first decision expressly recognizing that a defendant in the main action may seek a disclosure order under Rule 190. And just briefly on this decision, the case arose in the context of a fraud litigation. Panasonic sued Oppo and Xiaomi for patent infringement, and Oppo requested disclosure of comparable license agreements in support of its fraud's defense and counterclaim. In this case, the Mannheim local division refused the request and Oppo appealed. The court considered that the request was premature at this stage of the fraud proceedings, but in the decision we are discussing today, Establishment Light against GC Aesthetics, we are precisely in a situation where the defendants in the infringement action requested a disclosure order. And yes, just finally, before turning to the analysis of the decision, in its case law, the UPC has progressively clarified the conditions governing disclosure orders to produce evidence, and in particular the Hague Local Division, in its decision Wino versus Orbisk, identified 4 cumulative conditions that you can see on the screens. First, the requesting party must already have presented reasonably available evidence supporting its allegations. Second, the requested evidence must specifically identified and must be under the control of the opposing party. Third, the opposing party confidential information must remain protected. And finally, any disclosure order must comply with the general principle of proportionality, equity, and fairness. And this is these 4 conditions which are precisely the framework that the Brussels Local Division applied in the Establishment Lab decision. So in its procedural order of last 14 April, the Brussels Local Division provided clear guidance on requests to produce evidence. With regards to the fact the case concerned an European patent relating to soft tissue body implants and breast implant technology, Establishment Labs brought the infringement action against GC Aesthetics and several affiliated entities of the group, and the infringement action has been filed in October 2025. The defendants filed a statement of defense together with a counterclaim for revocation in February 2026. And in March 2026, the defendants submitted an evidence production request. And what is particular in this case lies in the wording of the asserted patent claims, which you can see reproduced on the screen. The defendants argued that the claimed surface parameters were unusual because under the standard ISO methodology, those parameters are normally measured over a reference area of 4 square millimeters. However, the patents use different measurement areas, such as 1 millimeter by 1 millimeter. So the defendants essentially suggested that the patents relied on non-standard measurements area in order to avoid a direct comparison with the prior art. So the defendants argued that despite these unconventional measurement scales, the claim parameters could still be derived from prior art products commercialized by the claimant itself. So to challenge the validity of the patents, the defendant's thesis, so you understand, is that the breast implants materials, so-called Motiva silk surface, allegedly produced, marketed, and sold by Establishment Labs since 2010, already met the parameters indicated in the claims. So to support those allegations, the defendants filed an evidence production request seeking extensive disclosure, including notably physical implants sold prior to the priority date by the claimants and technical documents relating to these products. The defendants argue that to prove a lack of novelty or inventive steps, the Motiva silk surface breast implants must be tested, particularly using the unusual parameters mentioned in the patents. And the assertion on which the defendants based their request are first, the Motiva silk surface was made available to the public without any restriction and confidence before the priority date of the patents. And second, claim of the patent are invalid in light of the Motiva silk surface for lack of novelty and or inventive step. So the court examined the application in light of the 4 conditions established by case law, which we briefly discussed at the beginning of the presentation. On this first condition, the court adopts a prima facie approach. The defendants did not need to fully prove their invalidity case at this stage. What the court required was reasonably available and plausible evidence supporting the allegations. And in this case, the defendants produced evidentiary records. First, to support the allegation of pre-priority public disclosure of the of the opposing product. They relied on catalog, marketing brochures, clinical summary, and product qualification documents. And regarding the alleged lack of novelty and inventive step, the defendants submitted scientific publication, technical presentation, and comparative measurements intended to show that the patented parameters already be derived from the earlier Motiva products. And what is particularly important is that the court accepted predictive calculations and technical extrapolations as sufficient at the prima facie stage. So the court repeatedly noted that the claimant did not specifically challenge these technical assertions in detail. So the court, the threshold applied by the court is relatively low because the requesting party is not required to conclusively establish the facts, but only to present a credible and technically plausible evidentiary basis. On the second condition, the court examined whether the requested evidence was sufficiently specified and whether it was under the control of the claimant. And this discussion mainly concerned the request for the physical samples manufactured before the priority date, so the Motiva silk surface implants. And for the other documents, Establishment Lab did not seriously dispute the fact that the documents were under its control. So the debate concerns the physical samples. And regarding pre-priority samples, Establishment Lab argued that the samples had been destroyed pursuant to its standard 5 years retention policy and was therefore no longer within its possession. But the court noted that no evidence had been produced regarding the alleged destruction policy of the claimant. So the court required witness statements from authorized officer of Establishment Lab confirming the unavailability of the requested samples. On the third condition, the court addressed the protection of confidential information. Establishment Lab argued that several categories of requested documents, such as technical and regulatory documents, were confidential because internal documents and therefore should not be disclosed. But the court rejected this argument and referred to the UPC framework, which expressly allows confidential information to be disclosed where it is relevant to infringement or validity proceedings. And the court stated that the mere fact that documents are confidential or internal is not sufficient to refuse disclosure. So the defendants had proposed a confidentiality regime limiting the access to external legal team, independent experts, one designated employees, all subject to non-disclosure obligation. And the court granted disclosure subject to a confidentiality regime. So the court granted disclosure subject to a confidentiality regime. The defendants first had to identify the persons who would be authorized to access the confidential information, and if Establishment Lab agreed to those individuals, disclosure could proceed, and if not, the issue would be resolved through a separate confidentiality order issued by the courts. And on the last condition, on proportionality, the court distinguished between two issues. First, whether the request had been filed too early in the proceedings, and second, whether each individual request was proportionate. And for the first issue, Establishment Labs argued that the application was premature, but the court rejected that argument because it noted that neither the UPC agreement nor the rules of procedures impose a specific timing requirement for filing an evidence production request. A party may therefore apply for disclosure at any stage of the proceedings once it considers that the 4 conditions are met. So the court acknowledged that an evidence production request could still be refused if filed too early, particularly when it remains unclear which facts need to be proven or whether those facts are genuinely disputed. But in this case, the court considered that it was not the case because the defendants had clearly identified the facts they sought to prove, and Establishment Lab had expressly disputed those allegations. So the court also referred to an important point to the UPC objective of procedural efficiency and the time required for technical testing of the requested samples. It therefore concluded that the applications were not premature. And on proportionality, equity, and fairness, Establishment Labs argued that the requests were excessively broad, but once again, the court rejected that argument, referring notably to the fact that requested evidence was under the claimant's control and not publicly available. The court also noted that Establishment Lab criticized several requests as too broad, but did not clearly indicate which narrower categories of document would, in its view, be proportionate. So the court considered that it had insufficient information to reduce the scope of the request on its own initiative. The court assessed proportionally globally and introduced a conditional mechanism depending on how Establishment Lab comply with the order. In particular, if Establishment Labs produced the requested pre-priority samples and admitted that the relevant implant generation had been publicly available before the patent priority date, the remaining disclosure request would become proportionate. If it produced the samples but did not make that admission, the remaining request would still have to be complied with. And if the samples could not be produced and only witness statements were provided, the remaining request will also remain justified. So as to timing, the court acknowledged that the defendants had waiting more than 1 month after filing their statements of defense and court claims on 16 February 2026, filing the evidence production request application on 20 March 2026. So the defendants initially requested production within 14 days, but the court considers that this was too short in light of the volume of the documents. So the court extended the compliance deadline to 21 days. So finally, the court ordered Establishment Labs to produce within 21 days a broad range of technical, regulatory, and commercial evidence, including physical samples, test reports, technical specifications, and design history files. And if the pre-priority samples could not be produced, witness statements confirming their unavailability had to be provided instead. The court also introduced a conditional mechanism. If Establishment Labs produced samples and admitted prior public availability, the remaining disclosure request could be dismissed as disproportionate. The court also imposed a recurring penalty payment on 200 per day of delay to ensure compliance with the disclosure order. And lastly, the disclosure may be subject to Rule 262A confidentiality regime. So in conclusion, this decision confirms that the Rule 190 is becoming an important procedural tool before the UPC, and importantly, the case illustrates that evidence production requests may also be actively used by defendants to support invalidity or defense arguments. So parties before UPC, even claimants, must now anticipate possible disclosure or of internal documents from the outset of the proceedings.
Thank you so much, Audrey. Very interesting presentation. I was checking whether there was any question raised. There are no questions. I do have one in my mind. It's more a consideration than a question. I do notice that reasonable available evidence is contained both in Article 59 and in Article 60 of the UPC agreement. So this it is interesting to analyze the difference between order to produce evidence and order to preserve evidence, where the second probably lies only in the hand of the applicants, whereas the other one, as you stress perfectly, is an instrument both in the hands of the applicant and the defendant. And moreover, I would say that probably the order to produce evidence is when you identify, so there is
Exactly.
a specification, so criteria, requirement, so you need to specify the evidence that you need, while with an order to preserve evidence, probably you could somehow foreseen what kind of evidence are you going to preserve, but you do not need to be so specific. But
yes, this is one of the main conditions required by the court to file an order production evidence.
Okay, thank you so much.